We're supposed to have met on Monday. I subsequently, as the chair, gave another further opportunity, 2 days, Monday and yesterday. Hence, we resuming today. That would have to have given the public protector more time to see if she can succeed in her endeavors to have legal representatives here. We shared a lot of correspondence with you, colleagues, and it's important that we do that so that you are on the same page, almost on daily basis about what we're doing to try and get to a point where, in the limited time that we have, that we effectively resume the inquiry. I'm aware that the National Assembly Programming Committee, led by the Speaker, last week they met, they had discussed the speedy resumption of this process, and they've shared their views about what needs to happen and by what time this process needs to be concluded. We also account, we are an extension of the National Assembly, and so when that body of the Assembly meets, and because it's a programming committee, it looks at what will happen when and so on. And so they would have expressed themselves on the matter about why it is important at a certain time that we wrap up our process. We equally share their urgent sense of urgency and a sense of completion of our work. Perhaps what we're going to do today, I'm just going to, so that it will make sense of this to and fro festival of correspondence. I'm just going to ask Ms. Fatima Ibrahim, our legal advisor, to just give us a summary of where things are, and the intention as the chair, I wanted us to deal with in relation to legal representation. She'll give us that, and I'll then after that go back to the public protector and hear her out, given the fact that we would have attended the meeting to give a further opportunity. And we'll take it from there, colleagues. Let me at this point recognize Ms. Ibrahim to come in and just and she will speak on the things that we have shared with you, all of it, but just to give a kind of a key salient points of the matters. Ms. Ibrahim.
Thank you, Chairperson, and good morning to yourself, all the members and the evidence leaders and the public protector, of course. Chair, members would have noted that there is a number of correspondences that have been shared. They have been fast flowing since we last adjourned the meeting. So I don't want to take the committee through each and every piece of correspondence. It has been tabled and it is available for members to read in more detail, but rather I just want to try and capture where we find ourselves today. Chair, after we adjourned the meeting last week, you will recall that the issue that the public protector raised, and she can correct me if I'm not capturing it correctly, is that she was not in a position to engage CNECO Inc. or council, that had to be done by the PPSA, and that the effect of the letter of 31 March from the acting public protector had the effect of terminating the funding arrangements between CNECO Inc. And the PP, and therefore she was no longer in a position to be able to give instructions. Following that, Chair, we addressed urgent correspondence to the PPSA, asking them for clarity on this issue, because clearly there was an impasse between themselves and the PP. And in the meantime, the PP also addressed her own correspondence to the acting public protector. We then received correspondence which confirms the view that they had previously put on the table, which is that nothing prevents the PP from instructing the legal team that they did not terminate the brief, and that was the position that they intended to take in this matter. Because that correspondence was received by us, if I recall, on Thursday night last week, us having said to the public protector that we will resume on Monday, we then said to her, in light of this correspondence, and then taking the firm view that you can proceed to issue instructions to CNECO Inc. and in turn to your legal counsel, we're going to delay proceedings until today, just to afford you some additional time to take those necessary steps and sort out those housekeeping issues. We then, Chair, received correspondence from CNECO Inc., from Mr. CNECO, who would be the attorney on brief in this Section 19 proceedings, indicating that for professional reasons, they no longer act on behalf of the public protector. At the same time, members will also see that there is some correspondence that has come in from attorneys, RMT attorneys, who've indicated that they act for the public protector in the two litigation matters that are currently ongoing, and that would be the appeal of the recent High Court ruling on the recusal issue, and then on the new matter that's been brought to the Constitutional Court. They are not the attorneys on a record for purposes of the 194 inquiry, and they have not been treated as such by the chairperson or the secretariat. CNF Inc. then indicated that they no longer act for the PP. We responded to ask what these professional reasons may be, and inviting Mr. CNF to please come before the committee and explain, so that the committee can get a better understanding of where we now stand, because clearly the issue of whether the PP can instruct CNECO Inc. or not is now a moot issue if they are no longer the attorneys of record for purposes of these proceedings. So to try and get a clearer picture, that is what we had proposed to do. However, we have received correspondence this morning from Mr. CNECO indicating that he is not able to attend a meeting of the committee because of the issue of legal privilege that the public protector has not waived, and in the absence of her expressly waiving that professional legal privilege, he would not be in a position to explain to the committee what the reasons are for that professional relationship no longer existing. So where we stand now, Chair, is that it is not clear whether the public protector terminated that professional relationship or it's because of actions from CNECO Inc. But the factual position is that currently, as we have it on a record, CNECO Inc. no longer acts on behalf of the public protector in this matter. In the meanwhile, Chairperson, because we were taking parallel approaches to try and get a resolution on all of these issues, once we received notice from Mr. CNECO Inc. that he no longer acts for the PP, we also addressed correspondence to the CEO of the PPSA, noting the fact that the PP has previously expressed that she has no objection to using the services of the state attorney, much the same way that Parliament utilizes the services of the state attorney, and we have indeed done so to brief the evidence leaders. And we asked whether this option could be explored, given the correspondence received from Mr. CNECO. We received feedback on that this morning, Chairperson. We were copied in on the letter from the Solicitor General in a response to the CEO's request to them for clarity. The CEO, in fact, sent them a copy of our letter to her, asking them to please weigh in. And the Solicitor General has come back to say that they cannot act on behalf of the PP because according to them, it won't be feasible due to a conflict of interest. They have, however, indicated that they can assist the PPSA with outsourcing of private attorneys at the applicable tariffs within the PPSA. And there is correspondence from the PP previously where she indicates that Sianeho Inc. would have been her first choice, but failing them another set of attorneys by the name of Chani. And this was before Mr. Sianeho indicated that there's no longer this professional relationship. What the Solicitor General does go on to say in quite some detail, members will see that from the correspondence, is that the issue of funding and budget is extremely important, that it's not an open checkbook exercise, and they suggest that there must be a renegotiation of fees, a streamlining of the legal team, and the PPSA must actively seek cost-containing measures when engaging with the legal team. But Chairperson, that is the position that we find ourselves in, that the PP is present today without a legal team accompanying her, despite the length of time that has now passed. Thank you, Chair.
Thank you, Ms. Ibrahim. That's helpful. I think following that, I would have a number of questions to ask, but I think it's fair that I go straight to the PP and ask her to give a take of the situation, and perhaps I can come later and ask a few questions. Over to you, Public Protector.
Morning, Chairperson. Good morning to.
Just a pause, PP, and we seem to have a. Is it fine? They are showing us flowers and everything else.
We're just not here.
Okay,
But they can see that.
you can see. Okay, I need to see them. I don't want to see pictures. I need to be interacting with members here and members on the platform. So it's fine if they see me, but it's a two-way thing. Just quickly fix that and then go back to the PP. Yeah, they are beautiful portraits. I can go and check that somewhere, not here. Thank you very much. Are we back on?
Yes.
Thank you. Sorry for that, Public Protector. Over to you.
Thank you, Chairperson. Good morning to you and members of the committee, evidence leaders, and parliamentary staff, and members of the public. Chairperson, let me start by saying, indeed, after the discussion the last time, I wrote a letter to Public Protector South Africa to approach Sianeho, or alternatively Chana attorneys, and I indicated that as the executive authority, I cannot deal with operational issues because I wanted them to assist me. Well, the Deputy Private Protector responded and said, well, even the legal services or CEO's letter that I should be proceeding with the attorneys. So I was waiting for them then to approach Sianeho because they are the ones who are processing the payments. I don't do that. So until such time, then I discovered that Sianeho wrote a letter to the committee and indicating his unavailability. So secondly, Chairperson, I never said I agreed to use state attorneys. That's totally wrong. What I said the last time was that the issue of funding, where you get the funding to pay the evidence leaders, which is, I take it because Parliament is bound by the Constitution and Section 217 of the Constitution. State attorney briefs the evidence leaders, and surely where the budget of Parliament is utilized for that. I was saying the very same kitty should be utilized for paying my legal services when you were still looking for money. So I didn't even know that the Solicitor General was approached, and I wouldn't have agreed to that, because knowing the conflict of interest, that state attorney cannot brief or act on behalf of Parliament and act on behalf of the public protector, and hence we have a panel of attorneys within the PPSA, knowing that we are audited by the Auditor General and we should be following or the compliance to Section 217. So currently, Chairperson, as I indicated, that indeed Sianego was my first option because of wanting to finalize the process, and they had knowledge about the matter. And then I gave the second option. And I'm still saying, Chairperson, I'm not involved on operational issues. And I indicated in my letter to you that for the Public Protector South Africa, the CEO, the accounting officer, is obligated to facilitate the process, as they've done with Sianego, because they were asking for legal fees. Coincidentally, that's what the Solicitor General is saying, because understanding what the Constitution, Public Finance Management Act is saying, they should be that process of compliance. What are the legal fees? How to utilize them? Indeed, within the state attorney as well, they do have those requirements, how to charge, what the hours per rate or per page, and all those things. So that money should still, because it's state money, it's public protector's money, should be managed within the Public Protector South Africa. So I cannot be told by the Deputy Public Protector that there is 4 million, therefore you'll see to finish whether you pay for your accommodation, traveling, and the protectors which you are using, and all those. Because at the end of the day, I am still the public protector, and unfortunately, I cannot. And even when I was still in the office, I didn't involve myself in the appointment of legal attorneys. Legal services used to do that under the guidance of the accounting officer. So I am here, Chairperson, and indeed I indicated that if Sianego is not available, there is another attorney, because I wrote to the Deputy Public Protector, I requested the panel of attorneys so that I can check in the meantime which other attorney one can identify and utilize in the list. And that's what I did, Chairperson, after leaving here, calling the office, in fact, writing to the office, indicating that, informally engaging the legal team as well to check whether they are still willing to proceed, especially Advocate Mpofu, who's the lead counsel in the matter. And for now, though they have all other commitments and busy with other matters today, I think we know that they are in court. So they are available, Chairperson, as soon as we have an attorney who will then brief them. Unfortunately, this quagmire was brought to this committee by the letter of the Deputy Public Protector of the 1st of March. And we are here because of that. Thank you.
Thank you, Public Protector, for that explanation. Maybe just before I seek the following clarities, just to indicate that you remain under oath. I certainly have seen. Can you hear me?
verify. I was asking Teminkosi, why did you put me here? I should have been in the middle at least so that I can hear you. I'm struggling to hear you.
Okay,
to be
I did
honest,
hear
yeah.
you. Can you hear me now? Can you hear me now? Thank you. No, thank you. I was just saying, public protector, that you just to confirm that you remain under oath before I seek the following clarities. I also want to indicate that yes, I can confirm I've seen those letters you make a reference to, in which you state your standpoint and preferences in terms of attorneys. Mr. Sianejo has indicated that he's no longer involved in the matter because of professional reasons. He's put that in writing and has also indicated that he's not at liberty to share those reasons because you have invoked a legal privilege and not provided a waiver in that regard. So my first clarity is, can you share with this committee those reasons that you are referred to by Mr. Sianejo, apart from the funding issues, which have now led to a situation where Mr. Sianejo is no longer on brief. So that will be my first clarity, PP.
Oh, that's your first, so you'll ask another one.
Yes.
Chairperson, I think the letter to Sianejo, I was copied, and I think it's very clear here that Sianejo is saying that is very critical, that the letter of the 1st of March and the 29th of March, that's the first reason that as Sianejo, they are saying their mandate was terminated by public protector by that letter. So that's the first paragraph. It addresses that because irrespective of what the deputy public protector and the legal services are saying, Sianejo was appointed by public protector. There's letters where the previous CEO appointed Sianejo, and through legal services and all the litigation up until they were the people who represented me here. And that was done because they had the knowledge of the matter, nothing more, nothing less. And that was done to save costs. Instead of getting other attorneys to deal specifically with this process, they knew where the matter started from the empty zone complaint, the responses to the speaker and all those. So that's the first issue. So when the letter was written to them on the 1st of to me by the deputy public protector, I had to share with my legal team. And then as well, the CEO wrote to Sianejo asking them to cost the remaining part. And Sianejo responded and said, we cannot, because evidence leaders and them are still going to discuss in the back room to identify the time frame, the schedule and everything. That's the first reason. Secondly, for professional reasons, they decided for themselves that is an added issue, but the main issue is that they've terminated the service. For professional reasons, Chairperson, there's a number of between attorney and client where we discussed issues and strategies on how matters should be dealt with the Sianejo team and them preparing me for this process, but not only for this process. Remember, they were my attorney for a number of other cases, so it's based on that. So there's nothing I could say on the professional reasons which they are having. And I've seen here that they are also busy with some hearing and some other matters. But I think at the core, at the center of this matter is that their mandate was terminated. And I think, Chairperson, you would see that from all my letters, wanting to make sure that this process is finalized, expediently. I said Sianeho is still my first preference. And then they had other than commitments which they couldn't forgo. And for the whole month of April, they also had their own, charting their own work. So I wouldn't know, and I can't say what issue is the main issue from their side. But informally, that's what they said. They will proceed with other matters. And I think that's a right which is guaranteed between attorney and client to do that.
No, thank you for that, PP. I hear you on that. Quite clearly from where I'm sitting, let's, apart from the funding issues, let's just put funding issues aside. I'm interested in, and as I've asked the question, because they cite professional reasons. Let's leave the funding part, because that's what has held us back, and there's an intervention in relation to that. They are citing professional reasons for a brief that now it no longer exists, and I'm only asking that if you can share with the committee what those professional reasons are, because they get instructions from you, and they indicated that for legal privilege, and you have not provided the waiver in that regard. I'm interested what those professional reasons are. Funding issues aside, because there's a process to deal with that, including what the letter was indicating from Solicitor General. Just unless I've missed you when you explain what those professional reasons are, I would just want to help me repeat that.
Chairperson, I think the best way is for them to be here, for me to be here, and my legal team to be here. I don't know what are those professional reasons.
So you have no knowledge of professional reasons that you would have invoked in this matter, or that are now existing? Because they've done that in a written letter to us, that there are professional reasons that they are not citing. And I was asking you if you can share that, but your answer is you are not aware of
Not
existence of
necessarily
such professional reasons.
Not necessarily that I'm not aware of. The issue is there's client attorney privileges. So for them to say professional reasons, it might be that they've got a lot of other work they're doing, or it might be that because their services were terminated. And remember, Chairperson, these people, they were dealing with my matters at a very minimal negotiated rate, SCNF. So there's also that issue. Possibly professionally, they cannot sustain themselves by continuing to do my matter. So I think it's better to hear from them what are those, if they can disclose. So for me, I said I'm asserting my right to privilege between attorney and client, because there might possibly other things which I don't know. But as far as I'm concerned, is that the mandate was terminated, they continued with their life, and that's all I can say.
So also, as far as you're concerned, there is no problem with a professional relationship between yourself and Sianeho as things stand?
I don't know of any challenges. So I would say, Chairperson, the best way to handle this is that we resolve the issue of legal representation. If they are no longer participating, let's proceed with other legal representation which I've opted for, so that we can finalize the matter.
Okay. Perhaps at this stage, members, before one goes to a ruling, if there are any other clarities or questions that members have, based on what has been tabled, or Ms. Ibrahim, if you want to come in first, I will allow members if there's any question or clarities before we make a ruling. Ms. Ibrahim.
Thank you, Chairperson. Chair, I just wanted to place on record paragraph 7 of a letter from RMT attorneys dated the 5th of May. And this is, I see Chairperson put it up on the screen, where it says, given the fact that our client, and the client now being the public protector, is without any legal representation in the committee, and her eagerness to complete the process, but in a fair manner, she would have no objection to being represented by the state attorney, or for that matter, any other attorney, provided, of course, that this would be done in a manner which will be fully compliant with the binding order of the Constitutional Court. So, Chairperson, it was based on that paragraph that we then sought the assistance via the PPSA of the Solicitor General, because it has been our approach since the letter of the 1st of March, in fact, not even the letter of 31 March, to do whatever we can from the committee's point of view to assist the public protector. So that was the reason, PP, and perhaps we've misunderstood your attorneys, but it was based on that, that the ensuing correspondence was then sent to the CEO of the PPSA. Chairperson, if I can please ask for clarity for our own purposes, for when we decide after this meeting how we can further assist the PP. Am I correct in understanding that the PP has no objection to us putting these questions to Mr. Sianego? So in other words, you're willing to waive that right to legal privilege. And the reason I ask, Chair, is so that we can consider whether we should be writing to the PPSA to assist the PP in still retaining the services of Mr. Sianego and pursuing that, rather than jumping to the second possibility, which is to obtain the services of a new attorney, that might assist to take the process forward. Thank you, Chair.
Okay. Over to you, PP. I hope you got that clarity seeking question.
As I said, Chairperson, that I am not waiving my right to privilege. That's between attorney and client. And I don't think it's proper even. I saw the response of Sianego, and they were reminding this committee about what were their responsibilities in this particular committee. So if there's a client and attorney privilege, then I don't think it's fair for you to ask that, Fatima, to me to waive. And secondly, I think what we can do is for Public Protector South Africa and yourselves to speedily appoint the next attorney, and then we can negotiate how quick we can resolve them assessing whatever they are expected to do, agreeing on how the rates and the time which is allocated and the work which is now remaining, so they can assess that. So I think that's what you can do for us, or for me, so that we can proceed, because I would want to indeed proceed with the legal representation being present.
Okay, thank you, PP. I hope that's clear, Ms. Ibrahim.
Yes, thank you, Chairperson. So my understanding now is that we will not ask PPSA to pursue the avenue of using Sianego Inc., and that it is the understanding that we now move to the possibility of new attorneys. Thank you.
Okay, thank you. Honorable members, any clarities or questions?
Chair.
Honorable Mautwe.
Good morning, Chair. Good morning to the PP and the colleagues. Chair, I'm a bit lost, because when we adjourned the last time, we agreed that the matter of the PP not having a legal rep will be resolved. By the time we resume, that matter would have been resolved. Now, we're back here today. The agenda is very clear. It says the evidence by the PP. But we're still asking clarity on the issue that is still not resolved. The question that you just asked to PP, was it not practical for you to be asking like you've been doing? Clarity through letters and all that. Why must we all convene here to listen to you asking the PP simple questions that she could have asked via letters like you always do? Because the reality is that this agenda is misleading. We set aside time, Chairperson, to attend this meeting, to want to listen to the evidence by the PP. We've got other portfolio committee meetings. There's a parliament sitting right now, mini plenary sitting. We left all that to come here, only for you to ask the PP a simple question that you could have asked through a letter. This is pure abuse and waste of resources, honestly. Can the issue of the PP legal team be resolved? And us as the committee be called to come here and continue with this meeting? Not these things that you're doing. It's a complete waste of time. And the public is looking at us as if we're moomish, all of us. You now involve us in your moomish things. No, it's wrong, Chairperson, please. And you are asking the PP the things that you should have asked Yanejo. No, Chair, this is wrong. Please let the issue of the legal representative of the PP be finalized. Call us as a committee. We want to come and resume the work of the committee, not to be dealing with back office administration, please. Thank you.
Thank you. Honorable Zungula.
Thank you, Chair. Greetings to yourself, the members of the committee, the PP, the evidence leaders, support staff, everyone. Chair, I want to agree with my colleague. You'll recall that during the start of this inquiry, there were some teething problems that were identified, and it was suggested that there needs to be a back office to deal with such. Now, when the back office is dealing with such, it would save time from the committee in terms of meeting in this fashion to discuss things that should have been resolved in the back office. In the last meeting, and in fact, for the last few meetings, especially after the issue of the funding for the legal representation of the PP came about, it was stressed, Chairperson, that up until that process has been done and agreed to and everything has been sorted and the PP is here with her preferred legal representatives, we can proceed. You'll recall, Chairperson, that number one, the PP did not suspend herself. And there is a court ruling that states that the suspension of the PP by Mr. Ramaphosa was invalid and unlawful. Number three, Chairperson, that the Constitutional Court, in fact, even that suspension, it was clear that she must continue receiving the same type of benefits and rights she would ordinarily been receiving had she been not suspended, meaning the issue of legal representation has been, there was a commitment from the unlawful suspension. And also, in light of that, the Constitutional Court also said the process must include the legal presentation of the PP. At no stage the process must continue without legal representation. Now, we can't keep on going back and forth on the obvious. The obvious thing is that the committee must sit, the inquiry must proceed, having complied with that Constitutional Court order of ensuring that the PP does have the legal representatives. Now, I want Chairperson to put it to you that please convene the people that you need to convene in your back office at the times that are convenient for yourself. And then you can deal with these issues. But when you call a meeting where you are going to, the inquiry is going to proceed, like the agenda is saying that it is day of hearing the evidence of the PP, only bring us when that has been sorted and the evidence and the legal representatives of the PP are there. Because rightfully so, I want to agree a lot with my colleague here, is that there's plenaries that are sitting, and some of us, in the are taking part in various debates which needs our thorough preparation. Therefore, we can't be called to a meeting to hear what is should have been discussed and agreed to in another forum. So I want to move, Chairperson, that this meeting clearly cannot proceed, number one, because still the legal presentation of the PP is not here. So there's no way in which you can proceed having that not being agreed to and fixed, and it is now resolved. Number two, going forward, only bring us to a meeting when that has been sorted, so that we don't have to do this back and forth, because we've been saying the same thing over and over again about what the court has said, what is fair, even in a hearing at a workplace. There's always legal representation. Whoever that is accused, whoever that is, his case is being dealt with, he's always afforded legal presentation. But it can't be that Parliament, which is a lawmaking institution, is unable itself, when it is conducting such a hearing, to respect that fundamental right of ensuring that a person is represented by a legal representative of their choice. So, Chairperson, please call us when that has been sorted, then we can move on, Kakuhle. I thank you.
Thank you, Honorable Zongula. Honorable Malema.
No, Chair, I'm covered by the two previous speakers, morning colleagues. As you would know that we're busy with a lot of different type of things. And then to be convened like this, as if we are just people who have no responsibility except being on standby for this, it's a problem. We were told today that we're going to listen to public protector, and then the next thing we're here, we're listening to administrative issues, which shows that when we adjourn here, someone is not doing his or her job in the back office. She only speaks here because there are cameras and she wants to appear in cameras. But if you're a back office, you'll be someone who's camera shy, and then do all types of things, including asking people whether they waive their rights or not behind cameras. But because I like cameras, I don't do my work. I wait for the day when there are cameras, and then so that I can show my face and pretend to be doing some work. These questions that you're asking here could have been answered by Sianego, and the public protector is being nice. Someone writes a letter, you ask another person, what did that person mean? You are very fortunate you are not asking me such a question, because I will not have answered such nonsense. I didn't write you a letter. Go to the author of the letter and get the answers. But because it's done for the show, you are asking a wrong person deliberately, because it's for the show. For you, it's for the show. But for her, you are humiliating her. You are continuing to violate her on things that could have been done behind closed doors. What is this professional thing? Because the intention is to embarrass her. But if you're a professional, you would have asked behind closed doors, so that by the time we come here, we deal with the nitty-gritties of what brings us together here. Not things that seeks to embarrass someone. Stop embarrassing a woman. Stop wearing a tie in the morning with an intention to embarrass a woman. an African woman for that matter. Be ashamed of yourself.
Thank you, Honorable Malema. Honorable Nkosi.
Thank you, Chairperson. I just have two things. Firstly, is that I agree that the committee in its work throughout has to demonstrate transparency, and it on its own must be seen to be accountable through and through. And I welcome the transparency with which you are handling these issues and the consistency with which you do. But I just want to ask the following question on funding. I may have misheard, but are we having guaranteed funding for that 4 million, or are there still negotiations for additional funding? And that matter must be clarified, because then it helps us to determine the next steps. Yeah, I thought I had that there are negotiations, additional negotiations to try to resolve the issue of funding. I thought we had closed that matter when the PP said they have availed only 4 million, which they have sourced from their previous unspent budgets in previous financial years. I think it's 2019, 2020. Thanks, Chairperson. Otherwise, I'll follow your summary.
Thank you, Honorable Nkosi. We'll respond to that question. Honorable Sukas.
Good morning, Chair. I have lowered my hand, Chair.
Thank you. Honorable Myla.
Thank you, Chairperson. Chairperson, I want to go back to the actual constitutional court ruling on this matter, which was Speaker versus the Speaker of the National Assembly versus the Public Protector, and Democratic Alliance versus the Public Protector. And in that judgment, the court amended Rule 129 AD subparagraph 3. And it reads as follows. The amended rule reads as follows. The amended rule now provides that the Section 194 committee, quote, must afford the holder of a public office the right to be heard in his or her defense and to be assisted by a legal practitioner or other expert of his or her choice, end quote. Chairperson, I would argue that this committee has bent over backwards to afford the public protector the opportunity to be assisted by a legal practitioner of her choice, that we have done everything we can do, and we are being asked to do things that are outside the remit of this committee. I would argue that the fact that the public protector has not continued her relationship with Sianejo for whatever reason is nothing to do with this committee. Nothing is, absolutely nothing is preventing her from being assisted by a legal practitioner of her choice. And the key word here is assisted. It doesn't say represented, it says assisted. That's in the Concord judgment. I think that we need to be very cautious about overstepping into a realm where we shouldn't be playing. And I think we also need to be very cautious about entertaining these continuing delaying tactics, because nothing's preventing 3 weeks down the line the same thing happening all over again, and this committee then being delayed further. We are operating to a timeline. We do have a schedule that we need to keep, and I think that we need to take all of that on board and proceed. The public protector has indicated her willingness to continue with this matter. Well, now is her opportunity to express her side of the story and to put her facts on the table. She can be represented by whoever she chooses, or no, sorry, she can be assisted by whoever she chooses. But I think that we as a committee must insist that the process continues and that we hear her evidence as a matter of urgency. Thank you, Chair.
Thank you, Honorable Milam. I see Honorable Lomisa, you've come in.
Good morning, Chairperson and colleagues. I heard you say the speaker has insisted that these hearings must be processed to the conclusion as soon as possible. And I also read regarding the same message you are conveying to us. Given that between yourselves and the of representation, why this meeting today? And you yourselves, the speaker herself, to sit down and discuss this issue. The truth of the matter is that the public protector is not satisfied with the manner in which we are handling this matter, but she has now and again said, I'm ready to testify. So please, Chairperson, time is running out, as the speaker had said. Go to her office and also request the acting public protector to be present. And then you iron out all these administrative problems, because these are administrative problems, the way I see it. I do concur with the previous speakers who said, no, don't take chances, sort out the main problem. And the main problem is about legal representation. Thank you.
Thank you, Honorable Olomisa. I take it that those are the only hands from the members who wanted to speak on this issue.
Honorable Chair, my apologies. I'm experiencing load shedding, so my icons are not working.
Okay, I'll give you an opportunity, Honorable Majosi. Please go ahead.
No, thank you, Honorable Chairperson. To all honorable members, the public protector. No, Chair, I just wanted to concur with the honorable member from the DA who has just spoken now that I think the committee has been supporting the public protector, and we have given her enough support and showed that we want to proceed with the matter so that we get to the end of it. I mean, our program was supposed to end in June, but now with the challenges, it becomes very difficult. And to note that as the committee sits, it's public funds that are being wasted all the time. And if we have to postpone over and over again, then it will become a serious problem for us also to then explain why, because we must justify why we have been postponing the meetings and so forth. And I think since the public protector knows that she does have full support in terms of getting her legal support, but the term ends in October. If that time passes without us reaching any conclusion, it's going to be a serious problem, because then why would we still sit? What will be the justification that this inquiry will need to still continue? Because then the term would have ended. So I think we must really come to a conclusion that these proceedings, they do proceed, and we do what is expected of us, and also the public protector does what is expected from her side, so that we finish with this process. It's been too long. The estimated time at that present moment when we started, it was not it was not supposed to take so much time. So honestly, I think sometimes we're just playing tactic games here and trying to push time that we get to end of October and not finish with the inquiry. So I think we must be decisive on this one, Chair. And if we need to get also legal advice on how then to move forward, if cases like this, I think we should do that so that we are able to proceed with the inquiry. Thanks, Chair.
Thank you, Honorable Majosi, for your contribution. I just want to make sure that I'm not closing any other member outside before I come in. Thank you. None. Thank you, colleagues. Maybe at that point, honorable members, I think it would be important to just clarify a few things. When we adjourned the last time when we met, before we agreed for a postponement of 7 days, part of the summary that was given on the day was that when we resume, we'll be resuming either with the old or new legal support. Just to remind members. So it's clear today that the issue of the old legal support in the form of Sianeho has been confirmed that it's no longer in place. You would have received a lot of correspondence from that meeting up until today that is assisting you to understand where we are. There's been a lot of information shared with you about the kind of efforts that were put in place by ourselves in the last 7 days. The PP itself would have written letters. And when letters are written, there's a response needed, expected out of those kind of letters. So it would not be correct to say that or to project that nothing would have happened between them. There's been a lot of things that have happened. It's important to keep on respecting the process with all of its imperfections and challenges, and be patient about that. We've been very much patient up to this point, and we have advanced the issue of fairness. Nobody can really complain about that. What is becoming clear today, as would have been indicated even in the letter this morning from the Solicitor General, is that we now are at a point where we are going to need to get the legal support of the PP in terms of the attorneys of record. The PP has confirmed that as senior counsel remains the senior counsel in writing there to us. The issue that is being sorted out now is the issue of the legal support. And Honorable Nkosi, just to clarify the matter, what we're dealing with now is not money, it's not funding. Your understanding is correct that has been kind of made available. The issue that we are now trying to quickly get our heads around is the issue of the legal support that must be sorted as a matter of urgency. So that there's no confusion about that, because we have developed a program, the revised program that has been sent to you, that is in line with what is available in terms of funding. And the Solicitor General letter is also indicating that whatever that must be done will have to be done within the available resources, not outside of those resources. I hope that clarifies the issue so that there's no confusion about us not resuming. Is it because of funding? It's less about that. It's clearly about the issue of the legal support. Honorable Mailam, I take your point. in the clarity you bring around that, and that this matter is still going to be ventilated further, because sometimes it gets interpreted in a particular way. So one really appreciate that. I appreciate your comments, members, about your impatience for us not proceeding, and your eagerness for us to quickly resume and get to our business. Your criticism to the chair is well received. I don't think that I would want to protect our officials, as I always do. So if there's any criticism, it is directed to the chair, and I take that on the chin in terms of the issues that you have raised, because the officials work under the direction of this committee and under the chair. So there's nothing they do just on their own. It's also important that we keep this process very transparent in the manner that we've done, because it has been transparent from the start. It's going to be transparent until the end, because even at the point when we're the report, it's not going to be done in a dark smoke-filled kind of room. It's going to be done here. So questions are asked to the public protector. That's part of the exercise of accountability that we do. The public protector account to the National Assembly, and so we'll do it both here, but we'll also do it, as you would have seen in the correspondence, of the kind of questions that are being asked through those numerous letters, either letters to the PPSA, to the public protector, to whoever, or from the PP to the PPSA or to us. So there's been a lot of correspondence in that regard, and some of the issues I would have hoped that members would have picked that up. Therefore, in that kind of correspondence. So I think at this point, it will be fair in summarizing that the only issue now that we're attending, which with the assistance of the Solicitor General, pointed out in black and white that they are ready to assist in that regard, and the PP has indicated her commitment to only needing that legal support. That's a matter that if that's what you're sending out us to do, that we're going to urgently go and attend to and finalize. It's not funding, it's that legal support. And I would suggest, therefore, members, that perhaps instead of me saying let's resume tomorrow, you give us the time to quickly attend to that. The moment we clinch that, to be able to say to you, all of that is now in place, as I've indicated. So it would only be fair that then we adjourn the meeting, and that you will remain on standby, not because there's nothing else that you do. I've always indicated that point, that once we come into the May month, there's a stampede of programs, budget votes, constituency, everything else that is there. We are going to indicate, as a matter of urgency, to you, public protector, to the members, when we resume, because obviously whatever that will do, we'll be doing with also your knowledge in that regard. It's not something that we want to do without you not being part of that process. So I want to ask members that we will adjourn the inquiry now, and I'm not going to say come tomorrow. We'll indicate once we attend to that. I hope that's in order to all of you. Thank you. Just a clarity from the PP.
Yes, I wanted to, because I was not involved with that issue of Solicitor General and whatever, but the fact of the matter is that the letter I wrote as the executive authority, that the panel of attorneys.
Just go closer to the mic.
I'm saying, yeah, you see, Chairperson of the river. I was saying, I hear you consulted Solicitor General and what he says and all those, but I was not involved. But what I'm saying is that
We have not. The Solicitor General is a discussion between PSA and Solicitor General. We were copied to the letter.
okay, but I'm just saying the letter I wrote about the attorney of my choice, I will go with the second option. And then if I can be involved in those deliberations and everything, so that we can proceed, because I think PPSA was also having some strange way of dealing with this. And I think hence the last time I said, possibly the Auditor General should come in so that they understand. You cannot just give me 4 million and as a blank check, because there are laws to be complied with. Hence, using the panel of attorneys and the PPSA operationally, the accounting officer will still must handle the negotiations, the agreement, the legal fees, the timeframes, and all those. So I just wanted to clarify that. And then once that is done, then we can proceed. Thank you.
Thank you, PP. That was always my understanding, that whatever that we're going to do, you're going to be involved in that process. I'm aware of the letter you sent about Sianejo and the other attorneys. So that remains in order. There shouldn't be a problem about that. So thank you, members. So when we do that, it would also go with a revised program in that regard, when we give you that announcement of the resumption in a very urgent space of time. Thank you very much. The meeting is adjourned.
Recording stopped.